This is lecture 3 or topic 3 in LWZ 304 Administrative Law, the Ombudsman. Now you'll recall from previous lectures that the Ombudsman is one of 4 parts, if you will, of the so-called new administrative law package, which was new in the 1970s, not so much now, but it's still more or less known as that. And I just remind you again, the parts of that are the Administrative Appeals Tribunal, the Ombudsman, Administrative Decisions Judicial Review Act, or Codified Judicial Review at federal level, and Freedom of Information. Now, you will have already worked out, and it'll be emphasised when we get to FOI in the next lecture topic, that almost all states and territories have adopted most of the new administrative law package at various times over the last 30 years or so. So all states and territories have ombudsman legislation and have had for quite some time. All states and territories have freedom of information legislation. The Territory was the last one. I think the Northern Territory got it in 2003. And all states, I think it is, but Tasmania have an administrative appeal tribunal, or rather a civil and administrative tribunal, which combines administrative law merits review and a select body of civil judicial functions, if you will, like small claims and residential tenancies and so on. It's less common for the states and territories to adopt codified judicial review. Only a small number have that. Certainly the Northern Territory doesn't. Certainly Victoria doesn't. At state and territory level, judicial review is still very much a creature of the common law and equity. But certainly ombudsman, administrative appeal tribunals and FOI are creatures that you will see both at a federal level and at a state and territory level. Now the readings for this topic, as you can see, are Crike and Macmillan chapter 4 and your head shorter textbook chapter 5. Additional reading, as you can see, by Philippa Smith and Bruce Barber. The Bruce Barber one is a useful one to read because it's an overview, if you will, of administrative law, with particular emphasis on the ombudsman, but also on merits review tribunals and juxtaposing the latter against the role of courts. So it's a useful article for you to read at this stage of your studies to start to put all of this stuff together. The Philippa Smith one is also interesting, Red Tape and the Ombudsman. Philippa Smith was the Ombudsman at federal level for quite a few years, and her paper or speech is a really interesting one. Getting a bit old now, 1999, but still very relevant. The key takeout point, I think, from Philippa Smith's article is that the role of the Ombudsman is very much dependent on the qualities of the person occupying it, their personal integrity and prudence, if you will, not rushing in where angels fear to tread, but certainly being forthright, but also being sensitive to the role of doing something that will to some extent fulfill what we called in week 1 a green light function, or a partnership, if you will, between ombudsman and the public sector, where the ombudsman assists the public sector to improve rather than acting as a policeman. But the thing is, the ombudsman has to act as a policeman sometimes, and one might criticise some ombudsmen for being a little bit hesitant to step into that role when it's needed. But the trouble with doing that potentially is that the ombudsman may forfeit the goodwill and cooperation of some public sector agencies if they go in too hard and aggressively, if you will. Because the key message about the Ombudsman, the key points, and to some extent this is stealing the thunder from our seminar on this topic, but there are really two very important key points about the role of the Ombudsman, both federally and in all states and territories. Firstly, Ombudsmen typically have very, very wide investigative powers, almost but not quite as much as a Royal Commission. Powers to subpoena documents, seize documents, enter premises, question witnesses, and so on. They typically also have at least some investigative resources and personnel. So the Ombudsman does fulfill a genuinely inquisitorial function, much more so than, say, the Administrative Appeals Tribunal or the CATs. They're said to be inquisitorial in the sense that they're not just passive adversarial referees of a case that's brought by the parties. They can ask questions and raise issues for themselves, but the tribunals can't really investigate for themselves very much because they don't have the resources to do so. But the Ombudsman does. On the other hand, although the Ombudsman has very wide powers, as I say, almost as much as a Royal Commission, the Ombudsman has no determinative powers at all. The Ombudsman, unlike a tribunal, unlike the AAT or the CATs, does not make binding decisions which substitute for those of the public servant or agency that made the original decision. The Ombudsman only publishes reports and makes recommendations. And the department or agency or its minister are free to ignore those reports and those recommendations if they see fit. So it's in that sense that the Ombudsman's moral authority, if you will, their power of persuasion, their perceived clout and integrity is really important to the effectiveness of an Ombudsman. So as we go through the detailed slides, keep those points in mind. They're very important. As the slide says, over the past 30 years, Ombudsman offices have become firmly rooted as part of Australia's administrative law system. It means rooted like a tree, not rooted in the other sense of the word. Models are largely the same in each jurisdiction, although the devil is in the details. So don't assume that the state that you're practicing in has exactly the same model, because there will be differences of detail, and when you're a lawyer, the details matter. I'll be concentrating mostly on the Northern Territory model and to a lesser extent the federal model. I won't be really touching on any of the other states or territory at all. The definition of Ombudsman, according to the International Bar Association, is that it is an office provided for by the Constitution or by action of the legislature or parliament and headed by an independent high-level public official who is responsible to the legislature or parliament, who receives complaints from aggrieved persons against government agencies, officials and employees, or who acts on his own motion, and who has the power to investigate, recommend corrective action, and issue reports. So that's quite a good definition. In our system, federally, I might say, and at all states and territories, the Ombudsman is not either appointed to or directly responsible to the Parliament, unlike in most European jurisdictions, but is appointed by the minister, but is independent of the minister. That's important to note. Cannot be directed by the minister, cannot be sacked except for very serious misconduct or proven incapacity, and certainly all Ombudsman reports and so on must be tabled in Parliament. So there's a high degree of parliamentary oversight of the role of the Ombudsman, but unlike in Europe, the Ombudsman is not an officer of the Parliament. The Ombudsman is an independent officer or official of the Northern Territory, but is appointed by the government of the day. Independent, impartial, but appointed by the government. So a bit like a judge in that sense. An ombudsman's functions include the following: resolution of complaints by individuals about public agencies. That's the most important role of the ombudsman. Improvement of the overall standard of government administration by stimulating an environment of debate by agencies and consumers as to what standards of service and decision making should be expected. Identifying systemic problems in the public sector as opposed to just dealing with an individual complaint and making recommendations for systemic change. And monitoring the implementation of decisions made by external review bodies, including to some extent, at least before the Information Act, the FOI decisions, but no, they no longer have a significant role in that respect, but certainly monitoring the implementation to some extent of decisions made by external bodies like merits review bodies, especially the CATs, is a role as well. The other, I should have really put a fifth one, although because it's not quite a resolution of a complaint by an individual, but the Ombudsman also, according to the Act, has a function of receiving, well, they are complaints, I suppose, and ensuring the correction of incorrect information held by government agencies about an individual. But those complaints must be from the individual themselves. The individual can request correction of incorrect information about them held by the government. So that's a significant, or was a significant source of work for the Ombudsman. Less so now, because we, in the Territory now, we have the Information Act and the Information Commissioner, and that role of correcting incorrect information is mostly conducted now by the Information Commissioner. So the most significant role of the Ombudsman is resolution of complaints by individuals against public agencies. And in the Northern Territory, at least, I should say, in most years, the most complained against agencies, probably not surprisingly, are the police and the health department, especially hospitals. Increasingly, though, children's services in the Northern Territory has been attracting quite a few complaints in recent years, well, for reasons that will be apparent to you if you've been following the media about various royal commissions and scandals involving children's services and sexual assaults against children and so on. So all that's worth taking note of. You'll notice dot points 2 and 3 there are very much systemic educational roles. So they're about really, the green light role, if you will, the partnership between Ombudsman and government to try and improve the overall standard of government administration. Now this slide, and very much these initial slides are taken from the Crike and Macmillan materials on this topic. That's so those references at the top, 4.2.14 and so on, are references to the relevant paragraph in your Crike and Macmillan textbook. Criteria or grounds for report, this is at Commonwealth level. Let me say the grounds for report, errors, if you will, that may form the basis of report and criticism in an Ombudsman's report are very similar at Northern Territory level, but this is summarising the Commonwealth situation, that the administrative action complained about appears to have been contrary to law, that it was unreasonable, unjust, oppressive, or improperly discriminatory. Now keep in mind that they're not necessarily using that expression unreasonable in the same specific sense as in judicial review. You might want to have a think about that when we get to judicial review, and especially the so-called Wednesbury unreasonableness ground. was in accordance with a law or administrative practice that itself was unreasonable, unjust, oppressive, or improperly discriminatory. Now, I guess that's a nuance on top of dot point 2. Was taken for an improper purpose or was based on irrelevant considerations. That is very much parallel with 2 of the broad ultra vires judicial review grounds, but again is potentially wider and slightly less technical. Was based on a mistake of law or fact. Was one for which reasons should have been but were not given. Or the catch-all ground was otherwise wrong or unjust in all the circumstances. So those are the sort of criteria, the sorts of things that the Ombudsman looks at and can and often does report on. The functions and jurisdiction of the Ombudsman. Now this slide links to the relevant section of the Northern Territory Ombudsman Act, Section 10, and the relevant section of the Commonwealth Ombudsman Act, Section 5. And again, the Crichton-Macmillan textbook extracts a summary of the relevant Commonwealth provisions. The Territory provisions are largely the same. Core functions: to investigate complaints from members of the public, and 2, to undertake own motion investigations. In other words, where there's no complaint from a member of the public, but the Ombudsman has found out about things that suggest the need for an own motion investigation. I'll come back to that a little bit later, actually, in a contemporary Northern Territory context. 4.2.18, increasing emphasis on the Ombudsman providing training and publications aimed at improving administrative decision-making and complaints handling. Now again, that's your green light approach or partnership between Ombudsman and government. But again, own motion investigations, especially focused on systemic issues. As I say, I'll come back to that a little bit later. Now again, this is a Crichton-Macmillan slide, and the reference there, 4.2.23, is to that paragraph and the following ones in Crichton-Macmillan. Complaint work of the Ombudsman. The majority of inquiries and complaints, 70%, this is at the federal level, consists of initial advice to the complainant as to how to raise issues with the appropriate agency. In other words, most approaches to the Ombudsman result in the Ombudsman saying, look, you really should go and take advantage of the internal complaint and investigative mechanisms within the department or agency itself. So first tier review, if you will. You remember I talked about that last week in relation to the administrative tribunals. So there'll often be internal review avenues or ways of dealing with inquiries and complaints that don't require the Ombudsman to conduct a substantive investigation, or alternatively it might be more appropriate to refer them to some other external agency like the Anti-Discrimination Commissioner, for instance, or the Children's Commissioner, or the Auditor General, or whatever, although I'm not sure the Auditor General has own motion powers either in the Territory to any significant extent. Some complaints are administrative style and behaviour rather than substantive injustice to the complainant. And that sort of complaint may not be directly reviewable by a court or tribunal because the complainant may not have suffered substantive injustice. So they might conceivably be verging on whether they're an aggrieved person or not. Now, as we'll see, if they're not, if they just can't be viewed as an aggrieved person, then the Ombudsman doesn't have the power to investigate that complaint either. But the Ombudsman can take an own motion investigation. So if there's something that's not a complaint in the sense that the complainant is not aggrieved, they're just peeved about the style of the way in which the department has acted, but they haven't actually been substantively disadvantaged, but they've been treated in a fairly arrogant, contemptuous manner or something, the Ombudsman can investigate that of his or her own motion. Next dot point, as with the courts, there is an ability to look at whether an individual decision is lawful or correct. In other words, the function is not only systemic, but there is the power, and this is the majority, is complaints about the actions of departments or agencies, the administrative acts of departments or agencies about which an individual is aggrieved, has suffered substantial disadvantage to them as an individual. So it's not just systemic, and as I say, in fact, the majority is where the individual is aggrieved, and in the Northern Territory, the biggest sources of grievance are the police and hospitals and the health system and children's services. As I've already emphasised, but it won't hurt to do it again, the Ombudsman does not have any formal power to make a new decision, but can provide a remedy for incorrect advice, by correcting the advice, correct errors of fact and notify the department of that, and require the department to correct the record about that person, and develop standards for good administration. Right? So I suppose my earlier comment needs slight qualification. The Ombudsman does have determinative powers, at least to the very limited extent of being able to require factual corrections in a department or agency's record where that's clearly correct. But the thing is, the Ombudsman doesn't really do that much nowadays, because that function has mostly been taken over by the Information Commissioner under the Information Act. Again, this is a Crike and Macmillan slide, recommendatory versus determinative powers. I'm getting onto that again. There is a debate, although not a terribly active one, about whether the Ombudsman can be effective without determinative powers to set aside or vary decisions and substitute the Ombudsman's own decisions like the AAT or one of the CATs can do. And there's been some disagreement about that. Quotes from Crike and Macmillan include, if Ombudsmen were able to review and remake decisions, their status as disinterested observers could be undermined. So Groves clearly thinks the current situation's pretty damn good, recommendatory, persuasive powers, moral authority, but no legal authority to substitute decisions is the best way to go. Petrie, on the other hand, says, I would take determinative powers any day. Cases where there was only recommendatory power created a high level of frustration for the investigation officer and consumed considerable time and resources without a final satisfactory outcome for the complainant. Now, that does sometimes happen, perhaps happens not infrequently. But would it be better if the Ombudsman's powers included similar ones to merits review tribunals, where the Ombudsman's view of the correct and preferable decision substitutes legally for that of the original decision maker? I don't think so, and certainly most of the existing and past Commonwealth and State Ombudsmen don't think so either. Where should the Ombudsman be located in the framework of government? Most Ombudsmen think it's better in the executive branch than being regarded as being somewhere else. Should the Ombudsman be an officer of the Parliament as opposed to an independent agency within the executive branch who's appointed by the Minister but independent or impartial and can't be directed by the Minister? Well, certainly the parliaments both federally and in the states and territories have not to date embraced the European model, which is that the the Ombudsman is formally an officer of the Parliament rather than of the executive branch of government. That's the genesis of Ombudsman. So it's a Swedish term, so it actually doesn't mean ombudsman in terms of man versus woman. It's actually, in the Swedish language is Justitie Ombudsman, and the Justitie Ombudsman in Sweden was and still is an officer of the Parliament, selected by the Parliament and answerable to the Parliament, not selected by the minister, not an officer of the executive branch of government, but an officer of the Parliament. Isn't the case in any part of Australia, and there's no Australian Parliament thinks that it should be, and most of the Commonwealth and state ombudsmen persons don't think it should be a parliamentary office either. There have been alternative suggestions, and this harks back to a previous lecture and consideration that perhaps you could develop an entire fourth arm of government, the integrity branch of government, which might well include things like ICACs, auditors general, ombudsman, and so forth. Perhaps information commissioners, perhaps parliamentary conflict of interest commissioners. Parliamentary commissioners for parliamentary and ministerial codes of conduct. All of those could be in a fourth arm of government. So you would then have four arms of government: the legislature, the executive, the judiciary, and the integrity arm of government, as I say, consisting of ombudsmen and ICACs and so on. That suggestion is quite broadly supported by current and past ombudsmen. And look, it has quite a bit going for it, because there are distinct qualitative differences between the role of the legislature, the executive, being the two overtly political arms of government, the judiciary, which is absolutely meant to be non-political but have very strong adjudicative powers. Well, all these other bodies are different from all of those three things, aren't they? So perhaps there is a useful role, or it's a useful thing to consider, to have a fourth arm of government. You might even put newspapers in that, and the media. You could put the media in the integrity branch, couldn't you? And subject them to integrity review, perhaps. That would be interesting. I suspect that Murdoch wouldn't support that, and probably Fairfax/Channel 9 wouldn't support it, but it's not necessarily a bad idea, because the media do have an awful lot of power, don't they, in our political system. Ombudsman offices special issues. Now again, this is a Crike and Macmillan slide, litigation and the Ombudsman. On odd occasions, the Ombudsman has initiated litigation. One case is re-reference 8.5.5c. Another is, but conversely, it's much more common for court proceedings to be issued by a complainant against an ombudsman who fails to investigate fully or properly as far as the complainant's concerned. Cavadius and the Commonwealth Ombudsman is an example of that. There are also cases where the agency under investigation has initiated litigation to restrain the Ombudsman from investigating, including Booth and Dillon No. 2, ATSIC and the Ombudsman, and in the Northern Territory, and this was under the old Ombudsman Act, not the current one, Boyce and Owen in 2000. Boyce was a previous Northern Territory Ombudsman, and Owen was I think a police superintendent who argued that the Ombudsman had no power to investigate him because he argued that there was no valid complaint that could form the basis of the Ombudsman's investigation. Now, Boyce and Owen is somewhat less relevant nowadays because under the current Ombudsman Act in the Territory, the 2009 Act, the Ombudsman has the power, a clear power, to undertake own motion investigations against both departments and agencies and the police, whereas the Ombudsman didn't have that power in relation to police under the old Act. There had to be a complaint by an aggrieved person. There doesn't have to be now. Exemptions or exclusions from the Ombudsman's jurisdiction. Well, there are a few of these at both Commonwealth and state level. I've given you some links there to both the relevant provisions of the Commonwealth Act and the relevant provisions of the Northern Territory Act, but I actually extract some of the key provisions in following slides. But agencies expressly excluded from the jurisdiction of the Ombudsman, both at Commonwealth and NT level, and indeed in most other states and territories, if not all of them, include courts and tribunals, like the CATs, presided over by a justice or judge, magistrate or coroner. The Territory, it does include the CATs, whether they're presided over a judge or not. Agencies also include governors, royal commissions, auditors general, incorporated and unincorporated companies or associations not established for a public purpose. So, sometimes governments create, corporations that fulfill, basically private functions. For instance, a postal agency, say, or something like that, a body that provides services not under statute, an electricity provider, for instance, where there's a multiplicity of providers. So those sorts of bodies are generally expressly excluded from review by the Ombudsman, either because they're regarded as sort of privatised functions, or more commonly because they're bodies, individuals or institutions that are judicial or quasi-judicial and therefore are part of a hierarchy where there's appeals and reviews anyway. Governors, royal commissions and auditors general. Royal commissions obviously are themselves very important inquisitorial bodies, often presided over by ex-judges, and again, they don't have determinative powers, so it would be pointless to have a huge and powerful Royal Commission undertaking an investigation and making recommendations, and then an aggrieved person complains about that, and then you have the Ombudsman investigating the Royal Commission. That would be ridiculous, wouldn't it? Similarly with the Auditor General, and for the same reason, because the Royal Commissions and Auditors General, if we actually had an integrity branch of government, the fourth branch of government, they would be in the integrity branch of government, and it wouldn't really be very sensible to have one integrity body investigating another integrity body unless we wanted the integrity bodies to be gobbling up the entire gross domestic product, one might think. All right, now we'll look at some of the specific provisions about the jurisdiction of the Ombudsman and exclusions from jurisdiction, starting with Section 5, subsection 2 of the Commonwealth Ombudsman Act. And you'll see from this slide there are various things the Commonwealth Ombudsman can't investigate. Action taken by a minister, there's a similar prohibition, I might say, in the Territory Act, and I think in all states and territories. Action that constitutes proceedings in Parliament, action taken by a justice or judge, or by a CEO or other officer of a court when exercising a power of the court, or performing a function or exercising a power of a judicial nature, and that's officers like the master or the registrar or judicial registrar of a court. Usually those sorts of officers have substantial delegated judicial powers under the supervision of judges. And so it's inappropriate that they also be reviewable by the Ombudsman, because they're supervised by the judge and therefore part of the appellate structure of the court in many ways. So if you're aggrieved by something that they do, you've got your remedy within the judicial system. You don't want the Ombudsman dicking around with that. And for the same reason, we've got exclusions for magistrates or coroners. We've also got exclusions for actions taken against public servants at federal level, including promotion, appointment, termination of appointment, discipline, payment and remuneration, and so on. Because again, there's a detailed mechanism and hierarchy of review and appeal about those sorts of decisions. So if you're an aggrieved public servant, you're expected to avail yourself of those rights of appeal and review, not to have a second bite at the cherry by complaining to the Ombudsman as well, or after you've lost or something. So that there are good reasons, I think, for those sorts of exclusions. The Northern Territory Ombudsman's jurisdiction and the exclusions from jurisdiction we find in sections 14, 15 and 16 of the Ombudsman Act. 14, as you can see, says the Ombudsman may investigate administrative action of a public authority or conduct of a police officer, A, on a complaint, or B, on the Ombudsman's own initiative. Right, so that's how it now reads. So Boyce and Owen, that I mentioned earlier, could not now take place. The Ombudsman could investigate the alleged actions of Superintendent Owen, irrespective of whether there was a complaint by an aggrieved person. Subsection 2, the Ombudsman may investigate administrative action despite a provision in any act to the effect that the action is final or cannot be appealed against, challenged, reviewed, quashed or called into question. Now that rider or saving provision for the Ombudsman's jurisdiction is something that will mean more to you when we get to privative or ouster clauses under judicial review. But effectively what it's saying is, if there's a general privative or ouster clause in the Act, it should generally be interpreted as meaning there are severe limits to your ability to seek appeal or review in a court against an administrative action that's protected by one of these ouster or privative provisions, but it doesn't prevent the Ombudsman from investigating. Don't worry about that too much for the moment, as I say, because it'll mean more to you after we get well through judicial review. Now, as I said, it's 14, 15 and 16 we need to look at together to see the jurisdiction and exclusions from jurisdiction of the Northern Territory Ombudsman. 15 is important. The Ombudsman must not investigate the deliberations of the Executive Council or Cabinet or a committee of the Executive Council or Cabinet. In addition, the Ombudsman must not question the merits of a decision, A, made by the Administrator, Executive Council or Cabinet or a committee of it, or B, made personally by the Minister. Now, this is quite interesting, because it does mean that the Ombudsman can't investigate anything to do with Cabinet or the Executive Council, which is essentially the same thing, at all, but also can investigate matters surrounding a decision made personally by a minister, but can't question the merits of the minister's personal decision. But it is important to note that the actions surrounding the minister's decision, like what were the processes leading up to it, what was the information provided and not provided by the department or agency to the minister that led him to make the decision, all of that can be looked at by the Ombudsman. And similarly, the way in which the minister's personal decision was implemented by the department or agency after being made can be investigated. And of course, sometimes there may be a question about whether the decision was actually made personally by a minister. And there's a quite recent Northern Territory political situation that's really quite on point here. If you're a Territory resident, you may remember there's quite recently a Minister for Aboriginal Affairs and Resources and Energy, Ken Vowles, was dismissed by the Chief Minister, Michael Gunner, for supposedly being critical of him and his decisions and actions, and the Treasurer's decisions and actions surrounding a financial crisis in the Northern Territory. Now, subsequent to that, former Minister Vowles made a complaint to the Ombudsman, the Territory Ombudsman, which at the time of dictating this lecture remains unresolved, complaining that he, Mr. Vowles, had not made any public comments critical of either the Chief Minister or the Treasurer or the government's financial administration, but that he had written internal correspondence to his ministerial and caucus colleagues, private correspondence, and that someone within the Chief Minister's office had leaked that correspondence to the media, and the media, of course, then published it. So he said, well, look, and he was then sacked from the ministry on the pretext that he'd been publicly critical of the government and of the Chief Minister, whereas he asserts that he wasn't. He didn't do that, but that somebody leaked it from the Chief Minister's office. Now, the action and the decision to leak it would be reviewable, or is reviewable by the by the Ombudsman, because it would be presumably an action preparatory to the Minister's decision to sack Mr. Vowles. But then on the other hand, if whoever the Chief Minister's staffer was who leaked the relevant correspondence, and most people on the inside already know who that was that person acting on their own initiative, or were they acting on the direction or instruction or decision of the Chief Minister himself? Now, if they were acting on the direction of the Chief Minister himself, then perhaps the Ombudsman would not be able to criticise that decision or question the merits of leaking those internal documents. But that would be significant of itself, wouldn't it? If the Ombudsman were to say, oh, well, look, I can't question the merits of that. That would be tantamount to making a finding that the leaking of that private correspondence of one of his ministers on the authority of the Chief Minister, or had been done on the authority of the Chief Minister, which would be fairly extraordinary, wouldn't it? So I think Section 15 is very relevant and very interesting in the current political climate in the Northern Territory. Moving on, though, to Section 16.1 of the Ombudsman Act. This is not about your personal ministerial decisions, but a wide-ish range of other exclusions, which are pretty much like the ones we've already looked at in Section 5 of the Commonwealth Act. Ombudsman must not investigate administrative action taken by a person while discharging or purporting to discharge a responsibility of a judicial nature, or a tribunal or member of a tribunal, or in the performance or purported performance of the tribunal's deliberative functions. So that means Ombudsman can't investigate NTCAT, or in relation to processes prescribed under an act for conciliation or mediation in relation to a complaint, dispute, or other matter within the meaning of that act. So if it's at mediation or conciliation stage, the preliminary stages, the Ombudsman can't look at that either. They have to leave it to the internal processes of the agency. C, a person acting as counsel or legal advisor to the territory, for the territory or for a minister. So again, that can't be investigated by the Ombudsman. Can't investigate the coroner. Can't investigate preliminary examinations and so on in the local court. Can't investigate the DPP. Can't investigate a public authority in relation to the employment, promotion, transfer, or termination, etc. Again, on all fours with the provisions of Section 5 of the Commonwealth Ombudsman Act. Can't investigate the actions or decisions of the parole board of the Northern Territory or the chairman of that board. So quite a few exclusions from the Ombudsman's jurisdiction. Now here's another more general exemption, not specific to particular agencies or authorities, but one that you definitely should be aware of. Subsection 2 of Section 16, the Ombudsman must not investigate administrative action of a public authority not mentioned in subsection 1, for which there is a review right under the law under which the action is taken, unless one of the following conditions applies. A, the authority agrees to the investigation. B, on complaint by the person who has the review right, the Ombudsman is satisfied, 1, that it would not be reasonable to expect or to have expected the complainant to resort to the review right, or 2, the matter merits investigation to avoid injustice. So many, if not most, acts nowadays have rights to merits review to NTCAT in the Northern Territory. So prima facie, the Ombudsman should not investigate a matter where there's a right to merits review to NTCAT, and should only do so where, as it says, it would not be reasonable to expect the complainant to resort to that right. Now, that might be because they're impecunious, or it's too complicated, or whatever, or it needs the form of independent inquisitorial investigation that the Ombudsman can do, but NTCAT can't, and that therefore it's a matter that merits investigation to avoid injustice. Now, there's an interesting matter of this general sort anyway, again in the news quite recently, and that was, if some of you followed it, there was a controversy very recently about an Alice Springs motel. I think it was called the Ibis Styles Motel, where there was information and recordings taken by the ABC and complaints and so on, which appeared to show that the Ibis Styles Hotel and its then management had directions that Aboriginal guests should be accommodated in particular dirty inferior rooms in the motel, even though they were paying the same room charges as white guests. There's pretty strong evidence that that's exactly what was happening. But the ABC at the time approached the Northern Territory Anti-Discrimination Commissioner, who said, well, look, it's all very concerning and does look racially discriminatory, but I can't investigate unless there's a complaint from an aggrieved person. And that's certainly the case under the Anti-Discrimination Act. There's no own motion power. And by extension, the Anti-Discrimination Commissioner can only investigate and conciliate or mediate, and if the matter then can't be settled, it goes to NTCAT, but it can't get to NTCAT or indeed to the Anti-Discrimination Commissioner unless there's a complaint from an aggrieved person. Well, there were no Aboriginal guests who had directly made a formal complaint, although obviously there were some who complained in an informal sense to the ABC, but that's not a complaint for the purposes of the Anti-Discrimination Act. But the Ombudsman, of course, can conduct an own motion investigation. And because there was no aggrieved person complaining, there was no external review right anyway. So that would have been a matter, and still is a matter, where the Ombudsman could investigate if he or she was so minded. The current Ombudsman is a bloke, Peter Scheuer. If somebody, e.g. the ABC, were to approach the Ombudsman and say, hey, you should investigate this because it's, this is pretty serious, pretty grotesque racial discrimination, really, and the Anti-Discrimination Commissioner can't investigate it, but you can. That would be one area, and quite an important area, I think, where the Ombudsman can fulfill a very important role, because the matter, I think most people would believe, does merit investigation to avoid injustice. So again, an interesting contemporary example of how the Ombudsman's powers could be deployed in the public interest. But what is a matter of administration or an administrative action? We've seen there's a wide variety of departments or agencies whose matters of administration or administrative actions can be investigated by the Ombudsman, both at Commonwealth and Territory level, although there's also a significant number of exemptions. But what the hell is a matter of administration? Well, in general, matter of administration hasn't been defined in detail. It's only labelled as a matter of administration, which is a bit question-begging, isn't it? But it's been construed by the courts in a liberal manner. So administration has mostly been interpreted not in the narrow sense of management, but as denoting the performance as a whole of the executive function of government as compared with the areas of performance of the judicial or legislative functions of government. On the other hand, in Glenister and Dillon in Victoria, the Supreme Court invoked the doctrine of separation of powers to confine the State Ombudsman to investigating matters of administration arising during the discharge of functions peculiar to the executive arm of government. So the Supreme Court prohibited the Ombudsman from investigating administrative actions carried out within the executive arm, but in connection with the legislative or judicial arms. So it was held that the Ombudsman could not investigate delays in bringing prisoners to trial because those actions, though administrative or executive, related to the judicial arm of government. But nothing's ever that simple, is it? Because in some matters relating to litigation, even in Victoria, those administrative matters that related to litigation have been held to fall within the jurisdiction of the Ombudsman. For example, a complaint that an assault on a prisoner by a prison officer was condoned by the governor of the prison was held to be capable of investigation by the Ombudsman, and a refusal by the governor of a prison to refer, on request, a disciplinary matter to a magistrate was also held to be investigatable by the Ombudsman. That's two of the Booth and Dillon cases. The sort of accepted international definition of matter of administration is probably one that would be accepted by most states, but not necessarily in either Victoria or South Australia. In British Columbia Development Corporation and Freedman, which is a Canadian case, of course, Justice Dixon said, the phrase "a matter of administration" encompasses everything done by governmental authorities, in the implementation of government policy. I would exclude only the activities of the legislature and the courts from the Ombudsman's scrutiny. So that's the general view, but as I say, at least in Victoria and South Australia, arguably, or possibly more than arguably, the Ombudsman can't investigate the wisdom or otherwise of matters of government policy, even if they weren't personal decisions of the minister. Now, I'm skipping around a little bit here in terms of the organisational structure of the Northern Territory Ombudsman Act, but we're still on, what is administrative action, or what is a matter of administration? Well, at least to some extent, I mean, the qualitative nature of administrative action is not defined in Section 6 of the Territory Ombudsman Act, but its breadth is. Administrative action, it says, is any action about a matter of administration, which again is not defined, but includes a decision or act, a failure to make a decision or do an act, the formulation of a proposal or intention, even if there isn't a final decision or an act flowing from it, and D, the making of a recommendation, including a recommendation made to the minister or the administrator, and E, a decision or act taken in consequence of the making of a recommendation. So administrative action in terms of function, if not quality, is very broad. Administrative action of a public authority includes administrative action taken by, in, or for the authority, and administrative action taken by or for an officer of the authority in relation to or incidental to the exercise or purported exercise, so even if it's unlawful exercise, or performance or purported performance of a function of the authority or officer. And also it includes actions taken under a contract by, on, or for the authority. All right, so if it's taken under a contract between the authority and a private body where the contract may authorise or require that action to be taken, it can still be investigated by the Ombudsman. So administrative action is certainly very broad. Exactly how broad isn't absolutely clear, though. Now, I've already mentioned in the commentary on an earlier slide that the question of standing to make a complaint to the Ombudsman is similar to, as it says, the AAT and ADJR. So it's the general standard that applies to the administrative law package and for that matter to seeking equitable relief under judicial review. Must be a person aggrieved, a person who is substantively disadvantaged by a decision or action of a public authority. The relevant section in the Northern Territory Act is Section 21. I don't think I extract that on the next slide, but I do extract one of the provisions in the Northern Territory Act because about discretion not to investigate. So, as the second dot point says, even if a person is aggrieved in a technical sense, there may well be a discretion not to investigate. Section 6 is the central section in the Commonwealth Act, sections 31 to 36 of the NT Act, but the key section is 33, which I extract on the next slide. Right, now you'll find this sort of exclusionary or discretionary provision in many acts of Parliament of various sorts. The Ombudsman may decline to deal with or discontinue dealing with a complaint about administrative action of a public authority if satisfied A, that the complaint is trivial or frivolous or vexatious or not made in good faith, or the complainant does not have a sufficient interest in the action the subject of the complaint, even if the complainant is aggrieved in a technical sense. the disadvantage they suffer is not a very big one, so not a sufficient interest. Or C, the complainant has not made a complaint to the public authority about the action. So again, on a discretionary basis, even if you don't have a right to review by NTCAT or something, but you could have made a complaint to the public authority, you could have sought internal redress, and you've chosen not to do so, then the Ombudsman, in exercise of his or her discretion, can decline to investigate. So you should always advise your client to make an internal complaint, to exhaust their opportunities to make an internal complaint if they can. Now, there may be particular situations where it's unwise and perhaps even unjust to expect a person to complain to the authority itself. It may be they have a well-justified fear that if they did, they or their kids or family might be intimidated or discriminated against. And if there was some evidence to that effect, then it should be put to the Ombudsman, and the Ombudsman might well exercise the discretion to investigate, even though you haven't made an internal complaint first. D, I won't go over. You can just read that now for yourself. But there are these provisions that allow the Ombudsman to decline to investigate trivial, frivolous or vexatious, not made in good faith, insufficient interest, failure to make an internal complaint first. There are similar provisions, I might say, in the Anti-Discrimination Act. So the Anti-Discrimination Commissioner has the discretion to decline to deal with a discrimination complaint on similar grounds, if it's trivial or frivolous or vexatious or whatever, and that's relatively commonly exercised, that power. I was the senior principal legal officer of the Anti-Discrimination Office in the Northern Territory for a couple of years, and there's a significant number of complaints that came in that we viewed as trivial or frivolous or vexatious. And quite often ones from prisoners who were in prison for 10 years or more and had nothing better to do than dream up complaints about anything under the sun, like their dinner wasn't hot enough or something like that. And those were the sorts of things that could properly be dismissed or declined to deal with as trivial or frivolous or vexatious. Now, as I mentioned very early on in this lecture recording, the powers of the Ombudsman in terms of investigation are extremely wide. Power to examine witnesses, power to enter premises, power to seize documents, which is, documents are very widely construed and obviously includes videos and audios and digital information and so on. As it says, power to examine witnesses and so on. As I suggested earlier on, they're almost the powers of a Royal Commission, but not quite. An Ombudsman cannot compel a witness to answer a question which may tend to incriminate them. And that's quite important. The Independent Commission Against Corruption, for instance, in most states and territories, certainly in the Northern Territory and New South Wales, does have the power to compel a witness to answer a question, even if it may tend to incriminate them. But the saving quid pro quo for that is that information can't be used against them in a court of law to as evidence against them if they're charged with an offence. So therefore, arguably, it's not unfair to compel them to answer. Well, the Ombudsman can't do that. The Ombudsman can't compel a witness to answer a question. The witness is entitled to say, well, I decline to answer that on the grounds that the answer might tend to incriminate me, and the Ombudsman can't require them to do so. ICAC technically can, but Whether that often makes any difference is a little bit questionable, because what tends to happen before anti-corruption commissions is that if someone doesn't want to answer, then rather than saying the answer may tend to incriminate me, they usually have a miraculous failure of memory and say, oh look, I just can't remember the answer to that. So yeah, they can't be made to answer if they say, however implausibly, that they just can't remember. So whether the power to require answers to questions that may tend to incriminate is all that useful is a little bit questionable. Now the study guide has more extensive information than this about acting on recommendations and about reports and what happens after the Ombudsman makes a report, detailed stuff about the Ombudsman's powers after investigation to make a report, and provisions about review or appeal from the Ombudsman and so on. I do more than suggest that you read that, but that's the end of this lecture recording. Next week in topic 4, week 4, we go on to the fourth leg of the new administrative law package, Freedom of Information lecture. But until then, that's your lot.